Hi, everybody. First, let me say thank you for joining us this evening. It means so very much to me and to our board of directors. For those of you who may not be familiar with the Institute, we were founded in 2004 by then retiring Supreme Court Justice, and our mission at the time was to draw attention to state constitutional principles, and we were trying to enforce state constitutional limitations on government via litigation. And I first joined the Institute back in 2005 and worked with it for many, many years. But about 5 years ago, our board decided to sort of let things go, let things quiet down, figure out what would be a better, more effective way to ensure freedom and fairness and economic liberty. So what we did is we sort of went to a dormant phase. And this summer, our board decided, through the generosity of the Pope Foundation and other generous donors, to restart. And this time what we're going to do is try to work collaboratively with not just the legislature, but also with public officials at the city, town, county level, and also with agencies. And in order to promote both freedom and economic prosperity, we're going to focus on three principal areas. One will be education law, making sure that we can preserve the progress that we've made in school choice, making sure that government, thank you, and making sure that government does not determine, as they have for decades, that they know more about our children than we do as parents, because ultimately the people who are most responsible for their children and have the greatest vested interest aren't bureaucrats, they're moms and dads. So we want to keep up. And then we're also going to look to emphasize regulatory reform and the separation of powers. For those of you who don't know, I've been on the Rules Review Commission for 8 years now, and that's the agency that's the final approval for virtually every rule or regulation in the state of North Carolina. And some folks here, Mr. Poley served with me, Mrs. Snyder is one of the staff council. But we really need to make sure that if agencies and bureaucrats are promulgating rules and regulations, that they have the statutory authority to do it, that they are not usurping statutory authority, and further, that the legislature has a full and comprehensive understanding of the real minutia of these rules. And unfortunately, we don't have anybody who's really been focusing on that, and certainly not from a separation of powers constitutional perspective. Now, in order to make sure that all of these things proceed, we're also going to have to focus on election law and redistricting, which, as some of you may have seen in news reports and on social media, yesterday we took our very first official action by requesting the public records from both Representative Deb Butner and Representative Darren Jackson, because I'd really like to know what it is that the Democrat minority whip was talking about during her rant on the House floor when she said, "We are right now downstairs redrawing the maps." Ladies and gentlemen, that is not the way that process is supposed to go. The court was crystal clear about it, and we cannot let it slide. So we have submitted that public records request, and we are ready to pursue any and all options available to us to make sure that the court order is complied with. Now, it doesn't matter whether you like that court order or not. Frankly, it's cringeworthingly flawed, but the fact is it is the court order, and it is the position of the General Assembly that they will comply with it in the interest of the people of North Carolina. The people deserve nothing less than full and complete compliance with an order of transparency. That is what the legislature has determined. The legislature represents the people, and that's what we need to move forward with. So, with all of that said, that's what we do. And notwithstanding our name, North Carolina Institute for Constitutional Law, we proudly receive no government funding. I wouldn't take it if they offered it. So at this point, we receive the bulk of our really essential funding from a principal donor, but we are a 501c3, and any contribution you can make would be greatly, greatly appreciated. And just to make sure that everyone here really fully and completely understands just how important the state constitution is, and it's never as sexy as the First Amendment or the Second Amendment or the Bill of Rights. Everybody's always talking about that. And those are obviously really important, but so is the state constitution. So we are very honored to have with us not one but two former Supreme Court justices, Justice Edmunds, who I have known since I was in law school and interviewed to clerk for him. He did not offer me the job, but I've forgiven him. It's taken 20 years. And also Bob Hunter, who served many, many years on the Court of Appeals, and then on the Supreme Court, and again on the Court of Appeals. So, gentlemen, I will defer to your honors as to the order of speaking.
Well, anybody who thinks judges are infallible can see that that's not necessarily the case. It's great to be back in Raleigh again, which I've not always said through the course of my life, but it is good to be here and good to see so many old friends again, and I really am happy to be back and really happy to see my former colleague and current friend, Bob Hunter, who's the better speaker, so we'll try to clear the way for him. But there are two kinds of surprise parties. The one is the one most of you are familiar with, where everybody hides and somebody comes in, everybody jumps up and goes, surprise, and everybody has a good time. This is not that type. This is the type where you're invited to a party, you walk in, and you're told you're the speaker. So my comments are necessarily going to be somewhat limited, though I do congratulate Dallas on pulling it off. I have known Jeanine the entire time I've been in Raleigh, all 18 years. And most of the reasons I know her is we were working on appellate law, constitutional law, things of those sort. And I know how much she's interested in it, how dedicated she has been to this, and what a great fit she is for this particular position. And the courts, the General Assembly, so many institutions here in Raleigh really need education about the state constitution. As Jeanette said, most people have some notion of what the U.S. Constitution says, in places at least. But people are still learning about the state constitution. And I think what she's going to be doing, picking up the work that she's discussing, is going to be just invaluable to all of us, not just in this room, but in Raleigh and across North Carolina. So, Jeanette, congratulations, and we're glad you're off to a flying start.
Well, one time I was campaigning with Bob Edmunds, and we went to the Stokes Surrey Barbecue Bluegrass Band thing, and Bobby was on the Supreme Court, and I was campaigning for the Court of Appeals for my first term, and it's in 2008, and we get in this long line to go up to the barbecue and eat the barbecue, which I can't eat anymore. Pigs see me coming and run now. I've eaten so much barbecue. And so we're going in line, and there's a lady up at the front booth, and she's selling buttons. And one of the buttons says, "I vote the Bible." I said, "How much are those buttons that say I vote the Bible?" And she said, "They're $1." I said, "I want 2 buttons. Here, Bobby, here's your button." Bobby says, "Oh, I can't wear that button. I'm a judge." And I said, "You don't vote the Bible, Bobby?" And we've joked about that ever since. And I can't believe two mistakes. You didn't hire Jeanette. I mean, I don't understand this. She didn't interview with me, though. I would have hired her if she interviewed with me. We got a lot of lawyers here, and I want to talk about my interest in the state constitution a little bit. I got fascinated with the state constitution when I was trying a case in the 1980s called Jingles versus Thornburg. And Jingles versus people don't realize the critical nature of that case. It completely transformed the entire country because it created opportunities for blacks and Republicans to get elected to office throughout the entire country, led to the Gingrich Revolution in 1994, and finally, after 100 years, 110 years, gave the Republicans a chance to win in the state legislature, gave us Republican judges and justices, and it was a groundbreaking thing. And I began learning what people are learning now about the Republican Constitution of 1868, which is still the Constitution we use today by and large. And there were so many things in it that people don't read about that were very radical for their time, and they're still considered very radical. And so it's fascinating to me to watch all these little nuances of when you find someone like the light goes on in some lawyer's head somewhere, and he actually sits down and reads the Constitution. And then he says, well, wait a minute, that applies to my case. So I'm in this reapportionment case or redistricting case right now in a side dispute about the Hoffler papers. Now, Tom Hoffler was a dear friend of mine. I used him for 30 years as an expert witness in every case in redistricting I brought. I've worked with him in Florida and South Carolina and California and Illinois and all over the country, and he was a genius. And he was so good that until he died, the Democrats really didn't know anything about him. And now they want his papers so they can, defame a dead man. Well, so we were trying to show that the property of Dr. Hoffler was privileged, and we're trying to get it turned back to us from whence it was stolen. And so I pulled out the Declaration of Rights, Section 1, and it talks about how people in North Carolina are entitled to the fruits of their labor. And this was a constitutional right that's put in our Constitution by the Reconstruction Republicans because it was important to them that newly enfranchised slaves had the right to contract and the right to property, which is something they didn't have before. Now, I'm working on a case up in Valley Cruces, and I sent my friend Chuck Kitchen up there, and he's taught me about the Emoluments Clause. I didn't know about the Emoluments Clause. As much as I've studied the Constitution, I knew it was there, but I really didn't know what it meant or what it says because I don't know what an emolument is. But now I've learned. And so I'm bringing a case in Charlotte for a group of black judges that may be controversial among this group. I don't know. But it's about a unified court system. What does it mean to have a unified court system where all the elections are the same for district court judge? Before I went on the bench, I got hired by 15 women in Wake County. Now, these were strong women. And they got together over the internet and raised $50,000 to hire a lawyer. They went to every major law firm in Raleigh to sue the school board, and they couldn't get anybody. They'd go in for the interview, they'd be shoved off to some young associate, and the young associate said, oh, hell yeah, we'll take this case. They'll run a conflicts check, it'll go to the management committee and say, oh, we're not suing the local school board. No, sir, we're not doing that. And so I got this case, and we brought about a change so that the Republicans actually had control of the Wake County School Board after that case. So it's very exciting law when you talk about the North Carolina Constitution, because it's our fundamental law. The legislature can't mess with it, by and large. And it's there in black and white. So to me, I think this institute is a great thing. And if you could educate the legislature about the Constitution, you'd have a full-time job, Jeanette. I'm just telling you. I mean, those people over there, I don't care if they're Republicans or Democrats, I don't think they've ever read the darn thing. And they need to read it, because it is so critical to everything. I'll tell you one more story, and then I'm going to stop. And Bob and I want to take questions, because I know some of you may have some questions about this. There's make 2 points. My Zen master that taught me law about the Constitution was Jim Trotter. And Jim Trotter was Governor Martin's senior legal counsel. And he was this thin, brilliant lawyer from Rocky Mount, North Carolina, who practiced in rural North Carolina. And his view was that you always start your legal analysis from the North Carolina Constitution and go down. And I recommend that to you or lawyers here, that you start there and then you figure out where the legislature has filled in the blanks. And if you do that, you'll always find your North Carolina constitutional issue. Now, there's one other thing I'm going to tell the lawyers here. There are 2 cases that are important in this, and that is, how do you get paid? Now, unlike Jeanette, whose stand on not taking government money is admirable, I'm prepared to take government money. And I'm particularly prepared to take government money in attorney's fee awards when I won against the government. I don't like the government. I'm an old line Republican. I like small government. And when the government oversteps, I'm happy to be there to smack them back. And I think that's what lawyers and judges should do. They should be there to look after people. And I tried to do that when I was on the bench. Sometimes I was successful. Sometimes the Supreme Court was in error. So I just want to say that there are 2 cases on attorney's fees in North Carolina about how you can get them in state court. Beverly Lake wrote this brilliant opinion about if you combine a federal claim and a state claim together, and the core of the claims are the same, you can get attorney's fees. And then sometime later, there was a Court of Appeals decision that attempted to overturn that. But it's still possible to get attorney's fees and get government money, which is sweet, when you bring a constitutional claim. So I just want to say that I'm very happy that Jeanette's not taking that dirty government money, because it'll be more for me. So thank you very much. Bob, come on back up here. Does anybody have any questions they'd like to ask about the constitutional law and stuff?
The Article 1, right to a jury trial, would you all agree that the legislature's statute, in an attempt to modify the constitutional right to a jury trial and cap money damages, violates the Constitution?
Yes.
Sure seems like it.
Me too.
I think that I think there are going to be a lot of that type of things that are going to begin coming up through the courts to do that. I mean, this work is very controversial. I mean, as conservatives, conservatives aren't a monolithic group of people. They're economic conservatives, they're business conservatives, they're libertarians, they're fusionists, they're religious conservatives. I mean, people can have a healthy debate about what good public policy is, but the language of the Constitution is there for a purpose. And jury trials, in my view, promote democracy because you get a wisdom out of 12 people that you don't get out of 12 bureaucrats. And I just think I'm a big believer in the jury trial.
And unfortunately, the number of jury trials, particularly in civil cases, is increasingly diminished. You can be a lawyer who holds yourself out as a civil litigator and maybe never try a case. So, go ahead, Bob.
No, I agree. And the expense of the criminal jury trial is enormous. I mean, I don't think people realize, taxpayers don't really realize, it's now up to about $30,000 to house and feed a prisoner for 1 year. I mean, and the number of people that we put in jail is very large. I mean, I don't know what the cost-benefit analysis is. Of course, for really dangerous, violent psychopaths, it's the only place for them if you don't have a stronger punishment for that. But, you know, I know that President Trump and have done some recent reform, and Senator Tillis and the legislature did some reform work on that. But the cost of trials is, I mean, the criminal trials are really crowding out the opportunity. I brought a constitutional case here in Wake County to try to get some justice for my clients, and I was told that to bring a constitutional challenge and get a 3-judge panel under this new law of 3 judges, it would take a year before I could even get a hearing, because they're so crowded with constitutional challenges, and getting 3 judges together is really very difficult. So it's a problem, but I recommend to you, if you're going to bring a constitutional challenge, make sure you bring a TRO or a preliminary injunction, or you may not get. Skip Stan told me he waited almost a year or 2 before he can get a hearing on a constitutional challenge he was bringing. So it's a problem.
Thank you. Just a couple of parting remarks. One, thank you again so much for coming out to support the Institute, and more importantly, to support the firm conviction and constitutional limitations on government. Your support means everything. Now, as we go forward, we're going to be working, as I said before, trying to prevent constitutional violations instead of having to litigate them after the fact. And to that end, we have a new website, ncicl.org, and we'll be putting out a blog, we'll be tweeting. So if you would go and share those as we produce them, like our Facebook posts, forward our messages, retweet our tweets. All of that makes a huge difference. It can mean the difference between liberty and prosperity and disaster, quite frankly. So thank you all very much. Enjoy the food, enjoy the drinks, drive safely. Thank you.